welcome, Mr. Katsas, to you and your family. Thank you for your service and your willingness to come forward and serve our nation in a judicial role. Former Sheriff Joe Arpaio, who I think is well known to all of us.
I'm sorry.
The former sheriff,
Yes.
Joe Arpaio, was found guilty of contempt of court for continuing unconstitutional policing in spite of a court order. And in my view, it was highly unusual that he was pardoned when in that posture. One senator has commented that this pardon undermines respect for the rule of law. In your view, as someone who's before us for a federal judicial post, does using a pardon to interfere with the ability of courts to issue contempt citations and have them respected undermine the rule of law?
Senator, I haven't studied the legal question, whether the pardon power is qualified in the context of contempt. As a lawyer for the president, I can't comment publicly on legal matters affecting my client, and I certainly couldn't publicly criticize my client in order to advance my personal interests before you today.
I may have a follow-up question. I just am concerned more broadly about how we understand the scope of the pardon power and whether or not it's appropriate for it to be used in cases to thwart attempts by federal courts.
Yeah, I haven't studied it. I don't know of any limitations on it, but if the case were to come before me, obviously I would have to look at the relevant law much more closely.
You've had extended exchanges with other senators about your history of working and speaking on executive detention and in particular Guantanamo Bay. And you've defended enhanced interrogation tactics, including waterboarding, fairly thoroughly. I just wanted to ask a follow-on question to your previous exchange with Senator Durbin. Is it your view that the executive branch's ability to engage in torture cannot be constrained by Congress or the judiciary?
No, not at all. Actually, Congress has power under the Constitution to define and punish violations of the law of nations, and Congress independently has power under the Constitution to make laws for capture, and both of those would seem ample support for statutes addressing treatment of detainees.
And do you also believe that Congress can or cannot prevent detainees at Guantanamo Bay from accessing our federal courts?
Under the Supreme Court's decision in Boumediene, they cannot. I will tell you, Senator, I advocated for years for the government to cut off habeas rights. I advocated for the constitutionality of not one but two federal statutes that Congress enacted cutting off habeas rights. The Supreme Court rejected the government's position, and then I faithfully and fully and vigorously implemented that decision. If you look at my 2008 testimony before Congress, I said, look, the court has spoken, we have to implement the decision. I went to Attorney General Mukasey when we were faced with 200 habeas petitions. I said, I need help. I need 50 lawyers detailed to the civil division to do nothing but work on habeas cases. And I went to Chief Judge Lamberth and I went to Chief Judge Hogan, and I worked with them to develop case management procedures so that the district court and the government could faithfully implement that decision.
Thank you for that answer. Let me ask a last question, if I might. You've criticized a number of different opinions by Justice Kennedy, but one that I don't think has been touched on. In a speech to the Federalist Society, you called Justice Kennedy's decision holding overcrowded and dangerous prison conditions in violation of the Eighth Amendment's standard against cruel and unusual punishment, frankly shocking. And in notes on the court's opinion in Brown versus Plata,
Right.
You commented that it could produce a tsunami of increased crime and characterized it as a shocking and depressing result. Help me understand your criticism of Justice Kennedy's reasoning.
I believe that the comment about increased crime was a statement from the dissent. In terms of the characterization as shocking, what I most remember about the case was that it was going to result in the release of 46,000 felons, and that seemed pretty unusual.
Could it have also conversely resulted in significant public investment to improve the quality of prison conditions?
It's possible. I didn't follow the developments after the decision was rendered, so I don't know.
Thank you, Mr. Chairman.